Hey everyone, welcome to video 3.1.11 for the Legal Studies Guy. Today we're talking about the impact of cost, time and cultural differences, but as always a very quick quote. Gandhi, obviously very famous human rights figure. The future depends on what you do today. And again, just that constant reminder of do the work early, focus, work hard today, and you'll reap the benefits down the line, hopefully in your next SAC and then in the future on your exam in terms of legal studies. So, today, as I just briefly mentioned, we're looking at costs, time, and cultural differences and how they impact on the principles of justice. Just basically going to outline a little bit how expensive the justice system is, how long it takes, and then some of the barriers that people from different cultural backgrounds might face. Our skill is going to be a discussion, so looking at both sides, which we'll talk about a little bit later on when we look at the principles of justice. Yeah, how do cost, time, and cultural differences stop the criminal justice system from achieving fairness, equality, and access? Well, listen on and find out. So, costs. Look, this gets referenced regularly, and it got referenced quite a bit in our last video on the need for legal representation. And that is where the main cost comes from in terms of criminal matters. So, if you are an accused person, so if you're accused of committing a crime, obviously the state has made that accusation. A trained lawyer, particularly if it's an indictable offence, a trained lawyer from the Office of Public Prosecutions will run that case against you. A Crown prosecutor will come in to try and argue the case and prosecute you in court. So the government, we know, has extensive resources at its supply, and we know that therefore, in terms of your ability to get a fair trial, see the Dietrich case, and your ability to have the best chance of getting a finding of not guilty, particularly if you're adamant that you didn't do the crime, you're going to need a lawyer. And the fact of the matter is, the bottom line is lawyers are expensive. Really, really common, simple joke out there is about how cutthroat lawyers are and how much they love money. And in some cases, it's true. So, generally speaking, if you see a solicitor, and this is a lot more common for civil matters in terms of huge law firms that handle, contracts and commercial matters. But effectively, most law firms, solicitors might charge you for their work in 6 minute increments. So they're literally charging you if they do one thing for you that takes them 6 minutes, they're going to charge that. And they might be charging out at, say, probably at this stage, 200's low considering our current inflation over the last couple of years. They're charging out minimum 200, probably more 400 to $1,000+ an hour. So that 6 minutes of work might be costing you, up to $100 if not more. So solicitors or lawyers in law firms are expected to meet a certain level of what are called billable hours. Basically, hey, if you're going to come into work for 8 hours, we want to make sure that we can charge a majority of your 8 hours to a client. So they have to track their work. So you're paying that, up to probably well in excess of now $1,000 an hour for solicitor support at high levels. And then you've got to bring in a barrister to actually run a trial. And look, barristers are generally going to cost a minimum $1,000 a day. Some of the really publicly prominent barristers, you always hear allegations or not allegations, rumors that they're potentially charging $20,000 a day or more for their services. And if you look at the county court, the average trial runs for, I think at the moment, in advice to juries, the average trial runs about 8 days. Yeah, most trials are running for between 5 and 10 days in the courtroom. So when you need that barrister, so if you're say paying $2,000 a day, there's 10 grand. And the average median income in Australia, still around, it's in the 60s, I think. So there's, getting close to 20% of the median income just to run a 5 day trial, or pay a barrister for a 5 day trial. And we know that there are strong links between socioeconomic status and crime. And unfortunately, a lot of criminals come from lower SES backgrounds, and the relationship between lack of lowest levels of education and crime mean the people who actually need this legal support are often the people that are least likely to be able to afford it. Not to mention the length of a criminal trial, which we'll talk about more in time. But obviously, every time there's an adjournment, every time there is a delay, is increased cost of legal representation because you still need to pay your lawyers throughout that process. And yeah, there's that link between socioeconomic status and crime. So, unfortunately, a lot of accused people don't have the means to actually properly defend themselves. In terms of time, we know justice delayed is justice denied, thinking back to that right to trial without unreasonable delay. Look, bit of an older statistic, but it is around about a third of criminal trials across Australia get adjourned and relisted for another date. And this could be a range of reasons, availability of witnesses. This is, we're talking lower courts as well, but availability of witnesses, availability of, police prosecutors, all of the different things that can factor in that mean, hey, we can't run today. And then they're, relisted for a later date. And that's, someone has to take time off work to attend court on that day, and then they have to figure out when they can take time off again. All of that just increases stress and trauma, potentially, on an accused person, on a victim. It impacts all parties involved. But yeah, adds cost as well, again, as we said on that last slide. Um, Process is really long. I will note that we're going to have to be able to discuss these. So look at both sides. And again, considering that even though legal representation is really expensive, we know that that cost is getting you generally fairness and access and putting you on an equal footing. So there is that both sides already. And it's the same with time. So there might be delays, and this process, might take generally up to 18 months. I think at the moment the county court's hovering around that 14 to 16 month mark, time to trial. That does allow for really important processes like disclosure to take place so that you as an accused person have the ability to see the evidence against you at the committal stage and then post to then prepare your defense. Ultimately, that's going to help get a fair trial. So there is benefit to the delays and the long process and the pre-trial steps that occur. But at the same time, we know the increased cost, the increased stress, the increased trauma for potentially witnesses or victims are all negatives of this as well. So considering those both sides, and look, the justice system's getting busier. So the amount of cases has grown effectively year on year over the last 20 years. As a result, it's taken courts generally longer to finalise matters. Matters are waiting for longer to get their day in court. And that increased load then has, flow-on effects as new cases come up, etc., etc. So in terms of a few statistics around time, now I've got just a few things from annual reports here. I want to note that these annual reports are all 2021-22. The 2022-23 court reports for the Magistrates County and Supreme Court are now all released as well. Happened a couple of months ago. So I would strongly recommend that you hunt those down and have a read of them as well and try and find some of this information and see how it's changed, because that's a really good learning activity. But also 2021-22, courts were still really feeling COVID, and the impacts of it on the delays it caused trials. And the 2022-23 reports will probably start showing that lessening. Magistrates Court here, as at 30 June 2022, the Magistrates Court had 83,000 criminal cases pending. That means 83,000 criminal cases in the system waiting to be resolved, either through a hearing or a plea or similar, or a discontinuance. 40% of matters resolved or finalised within 6 months. But if we look here, this is a really important number. Number of cases pending for more than 12 months, 25,000. So that's close to a third of that number of the total cases waiting or pending. So we can theorise from there that there's around about 30% of matters that go to the Magistrates Court that are going to take longer than 12 months to finalise. So about 30% of matters are going to take longer than 12 months. And these are the summary offences, the less serious offences. 85% of cases were finalised within 18 months, meaning that 15% of cases are taking longer than 18 months to work their way through the Magistrates Court. It's a really, really long time. Think about in 18 months. In 18 months, some of you guys will be finishing or not finishing, but over midway through your first year of university, your first year of full-time work. Um, Imagine if you had that, a summary matter in the magistrates court hanging over your head for that time. A few stats on the county court. Important to note, the magistrates court has 83,000 matters pending, or had at that time. Across an entire year, the county court commenced in 2021-22, 3,600 criminal cases. So huge difference in caseloads, and that's a really important point about the court hierarchy as well, is the volume of matters that the magistrates court deals with in comparison to the county and Supreme Court. So only 3,600. Of those 3,600, 1,400 were appeals, so 37% were appeals, so a lot of their work, and 1,400 were contested matters, so 1,400 were trials, and then 24%, 900 were pleas of guilty. So once you get to through the committal stage and a case is commenced in the county court, accused people are more likely to contest than plead guilty. And at that point in time, the average to trial time was 14 to 16 months. So again, 14 to 16 months of this hanging over your head to then wait for a 5 to 10 day average trial length. So 14 to 16 months of this waiting, and this is for serious matters. So again, think about that trauma for a victim, for example. So impacts of time, can be really bad. And finally, Supreme Court, just looking at this case number again, 61 matters that they finalised, and they're finalising 85% of matters within 24 months. So about 15% of matters are taking longer than 2 years. 45% of matters within 12 months. So what that effectively means is, again, we can probably theorise that the average time is going to be around that 12 to 18 months again, with not many getting out towards the 2 years, but that does still happen in some. And you'll see here, much more likely in Supreme Court matters to plead guilty, 38 went to plea, whereas only 15 went to trial by jury. Which is just an interesting stat compared to the county court, where there's a higher volume of matters, and it might be the types of cases that they hear theorising on those things. Last thing we need to look at the impact on is cultural differences. And look, this is really focusing on the idea that whilst Victoria is an increasingly multicultural society, our legal system is constructed based off the English system. A lot of hidden rules, common law is still a big component of our legal system. So effectively tradition and precedent. We're slowly getting rid of things like wigs and stuff like that, but lawyers are still wearing gowns. Until recently, we were calling them kings or queens counsels as opposed to senior counsels. There's a lot of tradition in our system, and to be blunt, it's white tradition, and it's really, really hard to access for, again, people from low SES backgrounds as well, but also people from different backgrounds and people who are perhaps immigrants or also Indigenous Australians. The system's not really well set up for them. So we talk about things like language barriers, and this all effectively speaks to access, so lack of understanding, ability to engage, and then the flow on of that is that you're at a disadvantage, so lack of equality, and you're unlikely to get to the right outcome. You might be viewed with prejudice or bias if your English is poor, for example, and you're facing a jury of 12 who are fluent English speakers. So access is very much the starting point for cultural differences in terms of its impact, but it flows on into the other two principles as well. Immigrants might come from places or backgrounds where police are, there are higher levels of corruption. Police aren't maybe necessarily the legal system to be trusted. That can cause challenges with engaging in the system. Language barriers is a huge one, and we have a lack of interpreters in Victoria at the moment, which impacts, you need an interpreter to be able to understand what's happening and engage with the system. Different countries have different systems of trial that might impact people from different cultural backgrounds. And then Indigenous Australians. And look, you see articles on tribal law from time to time. It's probably something that impacts more in places like the Northern Territory and WA. You don't hear as many issues where tribal law is in conflict with state law in Victoria. But there are definitely impacts around things like the hidden rules of questioning. There's definitely in Indigenous culture or some Indigenous cultures, a tradition of, um, you don't make eye contact as much when people ask questions. You know, things like that that can cause a level of bias or prejudice from a jury who is analysing you and trying to decide if you are um, reliable as a witness or not. And that can then obviously have a flow on impact into the outcome of cases, whether an Indigenous person is a victim or the accused person, so on and so forth. There might be language barriers in terms of Indigenous Australians who speak a native language as opposed to English as a first language. And then perceptions of police. We know there's been some particularly horrible stuff in recent years around Indigenous deaths in custody in Victoria, leading to some changes with our bail laws. And it does limit access for Indigenous Australians in the sense of they are less likely to report crimes based on these perceptions of police or cooperate with investigations, and how that then is perceived in both trial but then particularly sentencing. So, really, really important to understand how cultural differences usually firstly impact on access, and then that flows into equality and fairness. Now, the skill here, like I said, is discuss. And we know a discussion is an exchange of opinions. So we need effectively two sides. So we're talking about the impact of cost, time, and cultural differences on fairness, equality, and access, but we need two sides to that. So we need to talk about both the negative impact, which is pretty straightforward, costs a lot of money, takes a long time, people from different backgrounds likely can't understand and engage with the system as well. But we then have to look at the opposing side, and it's like, what are you getting for that cost? Well, you're getting a lawyer who's going to help you engage, going to help you get a fair outcome. What are you getting with that extra time and delays? Well, you're getting processes that promote fairness and promote equality amongst the two parties. Cultural differences, we're supplying, even though there's a lack of them, we're supplying things like interpreters, access to the Koori court for sentencing for Koori offenders that are trying to address some of those things. So there is definitely two sides to each of these. And I've included that in our principles of justice table. So you can definitely read into this stuff here. Um, and, there's other aspects of the system that aim to counteract these impacts as well, around, the existence of legal aid and CLCs. Again, you're getting the best evidence presented from lawyers, um, parties on both. Even though you're paying for legal representation, it puts you on the same footing as the prosecution. But those impacts are really, really strong as well. I referenced Dietrich earlier. If you are unrepresented because you can't afford it, we know that the High Court has clearly said that in serious crimes, that is going to lead to an unfair trial, and the trial should be stayed until you get representation. Delays add to costs. The costs put you at a disadvantage compared to the prosecution. Delays disproportionately affect an accused person. How much skin does a prosecutor have in the game compared to the person who's actually alleged to have committed the crime? So that one there. And we know like cultural differences and then the lack of legal representation are really going to strongly impact your ability to engage with the justice system. So on access here, I could chuck in about interpreters as well, and the Koori Court, which are both aspects of our system that aim to support and achieve access for people from different cultural backgrounds. So the synthesis, I'll link these two things here, a couple of older articles around some of the delays that occur and the cost of court cases in Victoria. I will also link in the annual reports for the last 3 years, the 3 courts in Victoria, so that you can potentially go and have a little read through those. But at the end of the day, if someone asked you right now to explain how costs can impact the principles of justice, I'd hope you'd be able to really, really clearly outline both sides of that equation, and the same with time and cultural differences. As always, feel free to leave feedback below, but look forward to seeing you for video 3.1.12.